Hey everybody, Ashley Page here. Thank you for taking the time to view our joint webinar that was done with the Birmingham office of Constangy Brooks. We did that for the purpose of giving you as much employer-employee rules as we can on COVID-19, also for the payroll protection program, and also for individual investment changes under the CARES Act. So you will see the webinar, which is about 2 hours in length, in three facets. The first one is the one done by Constangy Brooks, the second one done by me on payroll protection, and the third done by Jay McGowan, our head of financial planning. So we greatly appreciate you taking the time to view it. If you have any other questions of Jay or me on the Five Plan side, please feel free to give us a call. We're happy to help. Thanks.
Brooke and I are going to start it off here with some employment-related discussions, mainly about the Family First Coronavirus Relief Act and some other related legal issues. But we're glad you decided to spend some time with us this morning. If you're like me, you need a haircut and probably about 3 solid months in the gym. And hopefully we'll get back to some of those things soon. But we're going to share our screen here as a PowerPoint presentation.
So, today we just want to make sure that you understand we may not be able to answer, all of your questions today, but we're going to do our best. Guidance is coming out every day. Things are changing, rapidly changing, and some things that, you knew before may have changed. The Constangy website, www.constangy.com, also has, just on the very first page, if you go on there, there's a link at the top that our firm has been putting together articles just related to federal laws and also state-specific laws. So that's a really good resource that we wanted to point out to you. And finally, the last slide of our presentation will have our contact information on it. You probably also got our contact information on the invite. So if we're not able to get to your questions today, please feel free to email or call us and we'll do our best to answer you.
And the firm as a whole has been putting out a ton of content almost daily, sometimes several times a day, emails to clients and those on the distribution list. If you'd like to be on the distribution list and receive those and you're not already, feel free to email Brooke or I and we'll make sure you get on those because they're coming out constantly. Things are changing daily. So, for example, if you haven't seen, just yesterday, the CDC added 6 new potential symptoms for this coronavirus or people with COVID. So before it was just coughing, shortness of breath, and fever. And then as of yesterday, they've added chills, repeated shaking with chills, muscle pain, headaches, sore throat, new loss of taste or smell. But look, I'm 46. I got 4 kids. I lead a relatively active life. I've got muscle pain and headaches just about all the time, but I don't think I have COVID. But I'm here to tell you that what we've learned as this process has gone on, what the CDC has learned, and I think what Brooke and I have also personally observed with some of the work that we've done related to this, is that as we move forward with this return to work plan, which I think, in the next few weeks, and probably this week in the state of Alabama, you're going to see the governor start disclosing how we're going to start returning to work. There's a lot of people that don't have symptoms or never have symptoms, but are carriers of this. And so it's going to be a real challenge to effectively keep this from spreading and more importantly, keep people comfortable to come back to work. And we'll touch on that a little bit today, but for the most part, we're going to stick to the Family First Coronavirus Relief Act and the obligations of employers. So I think everybody here probably is familiar with this slide. It talks about how the virus is spread. It's mainly person-to-person contact. They want you to stay 6 feet away from each other. You've probably seen that when you go to the grocery store or Lowe's. You have to stay 6 feet away from each other. It's mostly spread through respiratory droplets when somebody coughs or sneezes, and it can remain alive on surfaces for up to 72 hours. And right now, there's no specific vaccine, no treatments or vaccines really available for this. And I think that scares a lot of people. We're used to going to the doctor and saying, hey, doc, can you fix this? And the answer is yes. Here's this shot. Here's this pill. Here's this prescription. But that's not what we have here with COVID. It's basically treating the symptoms as best they can and then hoping that your body will fight it off and you can get better. And most people do.
So trying to figure out how to plan opening your business, I think that the first thing we have to realize is this issue is going to be around even when Alabama and other states start, loosening the restrictions and allowing people to come back to work, allowing businesses to open. How long is this going to last? This may be an issue until we get a vaccine, until we get herd resistance, until there's some kind of natural decline in this virus, which has happened before in other viruses. The current projection is that, up to half of the, population may get this virus. Will that yet to be seen. And as we've been told, the current actions right now are about saving lives and not overwhelming healthcare. So just thinking about that and thinking about the future and how you need to open your business for your employees, we're going to try to help you with that.
Right. There's more and more studies coming out and showing that there are a lot of people who've had this and just don't know it. Yeah. And, you can look and see that we've been successful in flattening the curve. And I think as we see these return to work plans come out, and look, some states have already loosened restrictions, like our sister state, Georgia. Look, I could have driven over to Georgia last Friday and gotten a tattoo if I wanted to, but that's not available here in Alabama just yet. But you can see that what we're trying to do is spread out the infections. And so I think you can see that we've done that initially, and then we're going to start slowly ramping up and see what the impact is, what the result is, and see if the new infections, new cases can stay under the level that the healthcare system can continue to treat and stomach. Because right now, it looks like we have enough capacity to treat the cases that we have there currently.
So, as this slide says, this too shall pass. Maybe like a kidney stone, but it will happen. We'll get through all of this together. We're trying to help you today with your game plan, adapting your business, adapting for your customers, for your employees, and surviving. The information and advice is changing daily. We'll get to a slide later that says, the CDC suggests that you do not wear a mask. Well, this slide was, created a few weeks ago, and now maybe the CDC says we should all wear masks. So things are changing.
Well, they actually do, and the slide has been updated to reflect that. So
okay.
You're a little bit behind, a little bit.
Okay, so you can see the different waves that we have that we've gone through, and hopefully now we're on the second wave of getting back to business. We're going to have to figure out what will happen with businesses if we do have a third wave, and then hopefully get into that fourth wave of treatment and managing the disease.
Okay, so the Family First Coronavirus Response Act, it was passed a few weeks ago, went into effect April the 2nd, and unfortunately during the last month or so, Brooke and I and just about every other labor and employment lawyer across the country has mostly been doing two things. One, counseling clients with the aspects of compliance with this particular law, how to provide the leave. And then unfortunately, the other thing we've been doing is counseling clients on how to do layoffs and furloughs and pay cuts and things like that. And that's particularly not very fun, but we've managed to get past that part for the most part. And we're starting to look at, well, what do we do? How do we get people back to work? And there's still a lot of questions about how to comply with the leave aspects of this FFCRA. Now, the law sets a floor. I want to make that clear. So the things we're about to talk about are the things you're mandated to do. You can do more, but I will caution you that, and we'll talk in more detail about the payroll tax credits, but if you do more, provide more paid leave, you're not going to get the federal tax credits for that. That's on you. And I've had this question before, does this make FMLA apply to everybody? So the FMLA that we're all familiar with, hopefully, that was passed in 1993, does this law make it apply to everybody? No, the FMLA is still the FMLA. There's been this expanded portion for a temporary period of time that runs through the end of this year. And the DOL, Department of Labor Guidance on how to comply with this, is updated constantly. And for a few weeks there, it was updated at least every other day, it seemed like. Things have seemed to stabilize, which is one reason why we wanted to have this webinar. But I mean, there was about a 2 or 3 week period there where we were giving advice to clients based on judgment calls about what we thought the guidance was going to be, what we thought the regulations were going to be. And now, that's an uncomfortable spot for a lawyer to be in, but we managed to get past all that.
So interestingly, a lot of laws, apply to the larger employers, but the Family First Coronavirus Response Act applies to employers with 500 or fewer employees. There's a lot of question about, how do you aggregate these, your employees to determine how many you have. But that's part of the act where it explains, how do you come up with your number of employees. Also included in this act is the paid expanded FMLA leave, the emergency paid sick leave. And those are the two areas of the law that we're going to talk about the most today. And they're the ones that we've been talking about with our clients. And we generally refer to those laws as the emergency paid sick leave and the expanded FMLA. That's just what we say, paid sick leave or expanded FMLA. There are some prohibitions against termination against your employees, such as retaliating against employees who have taken leave. There are some requirements for job restoration. Also in the act, there's a discussion about receiving the tax credit reimbursements that we're going to talk about. There's a posting requirement that you have to place a poster in your place of business. And then there's also some discussion about the unemployment grants to states, and we'll talk about that as well.
Just briefly about the 500 employee threshold. So interestingly, most of the time employers are trying to figure out how to have fewer employees. Yeah. How do we have 100 employees or 50 employees and exclude this group? Those are independent contractors. Those are leased employees. We don't want to count them. We have multiple locations. They're all separate entities. So these are all separate employers. That's normally the kind of debate that you have about this kind of stuff. Then all of a sudden this law comes around. You got employers trying to figure out, how do we get big? Yeah. How do we have 500 or more employees so we don't have to deal with this? And so I'll caution you that in the past, if you've been taking the position that you're a bunch of smaller employers, separate employers, and all of a sudden you've decided, no, that you're this one big entity, we're a joint employer. Most of the time, being a joint employer is not a good thing. You get saddled with a lot more responsibilities. If you may recall back when the Obamacare Act first passed, you had a bunch of employers trying to figure out how they had fewer than 50 employees so they didn't have to comply with Obamacare. I would caution you, and then we'll move on. Please don't play games about the 500 employee rule. Be consistent with whatever position you took in the past. Be consistent going forward, because if you publicly take the position, we've got 750 employees, we don't have to comply with this. Well, guess what? You may get that position may get force fed back to you in a year from now, when all of a sudden you're back to wanting to have 50 employees.
Right. So here's the poster, and if any of you do not have access to it, you can likely just Google and locate it. But if not, you're welcome to email us and we can send you a copy. But this is the poster that is required to be placed in your business.
So the emergency paid sick leave portion of this bill, again, 500 or fewer employees, it is all your employees are eligible. There's no minimum length of employment. That unlike in the expanded Family Medical Leave Act, that we'll talk about in a second, which requires somebody to be on payroll for 30 days. This emergency paid sick leave, they're eligible day one, and they're eligible for up to 80 hours of paid sick time at their regular rate of pay for their own illness or their own quarantine, which are reasons 1 through 3 that we'll talk about in a second, and at 2/3 of the rate of paid care for others, such as caring for a family member who's been quarantined or diagnosed with COVID, or more commonly right now, because all the schools across the state and frankly across the nation are shut down, employees are eligible to take leave to care for their child whose school or place of care is closed. Now there's a pay cap for the own illness reason, so that's $511 per day or up to $5,110 in the aggregate. So if you're keeping score at home, that's just 10 times, that's the 10 days, 2 work weeks worth of pay. And then for caring for somebody else or the child, that's the cap is $200 per day or up to $2,000 in the aggregate. You cannot reduce paid time off benefits if you have them, and for this particular type of leave, you cannot require the employee to use their existing benefits first. So what I mean by that is, if you have a paid sick leave, if your company that provides paid sick leave already, you can't reduce your paid sick leave bank and then have the employees take this, and you can't require the employees to use that sick leave bank before they take this emergency paid sick leave. Think of it like this. The government has mandated that this be an additional 2 weeks of paid sick leave, in addition to what you may already provide. And we've had questions about, well, hey, can we just eliminate the 2 weeks of paid sick leave or whatever paid sick leave they have for everybody instead of this? And what I have cautioned people about is this law has an anti-retaliation provision in it that we'll touch on in a little more detail in a second. I think if you eliminate paid sick leave for everybody or reduce everybody's paid sick leave, whether they take this leave or not, you're likely to get some sort of retaliation claim because at the end of the day, your answer in a deposition about why you did that is going to be, well, we had to give this other paid sick leave and we can't afford it, so we eliminated our existing paid sick leave. So I would caution people not to do that.
But right when these, when closure started occurring, when we were getting questions about that, I think we were probably telling them, yes, you can get rid of some of your paid sick leave. You can require people to take paid sick leave. And that was before this passed. So that was a situation where we were providing advice on what you could do to handle these closures or to handle these, cut in hours. And then this law was passed and now you've got to comply with it. So if you can see here on the pay where it says regular rate of pay for your own illness, which we've put 1 through 3, and then 2/3 of rate for 4 through 6. These are the qualifying events that we're talking about, and this is how they're labeled in the Act. So we wanted you to see it like this, and I know there's a few of my clients on the webinar now, and I'm sure they've heard me a million times say to them, the reasons 1 through 3 and the reasons 4 through 6, and that may be, difficult to understand if you haven't actually seen this, but this is how the law is worded, that the reasons 1 through 3 is when you can get the full pay up to $511, and then reasons 4 through 6 is the 2/3 pay up to $200. So that's how the law is worded.
So you can see there, if they get access to this leave, if they're subject to a government quarantine, which is sometimes triggered because they've traveled outside the country. That was one of the first types of quarantines we were dealing with. And then if they actually have symptoms or they've been or they're diagnosed with COVID, the government will quarantine them. Then sometimes an employee's own healthcare provider, their own physician will tell them to self-quarantine for various reasons. That can trigger this leave. Certainly if they are experiencing symptoms, so employee wakes up one morning and they think they're having coughing, shortness of breath, or now chills or shaking combined with chills, and they call in and say, look, I need to go to the doctor. I want to get tested. And they get this leave for as long as it takes them to get tested and then get that result back, which, by the way, if you haven't had any experience with this firsthand, doesn't happen in 24 hours. I mean, the testing is fairly limited. It can take a week or so to get tested and get the results back. Now, the employee needs to be acting in due diligence and going to seek the testing and have it done and everything. But that's a trigger. And of course, if the person is caring for an individual in their household, somebody they have a personal relationship with that has subject to a quarantine, or more commonly right now, if their child is home because the school's closed or their daycare is closed, then they can take this leave. And then reason number 6 really hasn't come into play yet. It's sort of a catch-all that allows Health and Human Services and the Department of the Secretary of Treasury, the Department of Labor to come in and in the future shove something into this bill. But right now, number 6 isn't in play. So you're really dealing with reasons 1 through 5 right now.
Okay, so now we're going to move on to the paid expanded FMLA leave. And we have to discuss how these two laws, work together. So to be eligible for the expanded FMLA leave, you have to be on, your employee has to be on your payroll for 30 days. The amount is 12 weeks of job protected leave. And this is a total of 12 weeks for the COVID-19 events plus all of the other FMLA events if your business has to comply with those. The waiting period is 10 days unpaid and then 10 weeks paid. But likely when you see how you become eligible for this expanded FMLA leave, you're going to see that most likely the person got paid the 2 weeks from the paid emergency sick leave. The pay rate for this is no less than 2/3 of their usual pay. The cap is $200 per day or $10,000 in the aggregate for those 10 weeks. And here you cannot require employees to substitute other paid leave, but you can allow it because if they have paid leave, they may want to receive the full amount of their pay rather than only the 2/3 of their pay.
So the way this works, these two pieces go together, they fit together. You got the emergency paid sick leave, the expanded FMLA leave. So the emergency paid sick leave allows employees to take leave for those 5 reasons that we talked about. And then for the reason number 5, which is the school closure or place of care being closed, the employee can then go on to expanded FMLA leave for an additional 10 weeks at $200 per day cap, and then $10,000 in the aggregate. So the emergency paid sick leave is a lot broader. And then as that time passes, they can continue on to the paid expanded FMLA leave to take care of their child because of school closure or place of care being closed. And that is, just FYI, when this bill was first introduced in the House, the paid expanded FMLA piece covered all the things that were in the emergency paid sick leave piece. But it got whittled down to just caring for the child due to school closure or place of care being closed. Just one of those legislative compromises to get this thing passed. The House bill was a lot broader and would have been a lot more problematic for employers than what we ended up with.
So you've got to think about, if you have, and I've had clients have this situation where you've got two employees that are off for, different reasons under the emergency sick leave. And then so you've given them both 80 hours of paid leave. And then you've got one of them who needs to continue taking off because to care for their child at home, who the school is closed. And you got another who is not out of quarantine or has some other reason unrelated to taking care of their children. Those are two different situations. We have to treat them differently, because the one that needs to take care of their child, the expanded FMLA leave might apply. But the other one who is just not out of quarantine or is still sick, that's not, the expanded FMLA leave is not involved with that. So you have to treat those two situations differently.
All right, so what about intermittent leave? So those of you who administer FMLA leave, you know that under the FMLA, you can take intermittent leave. And what I mean by intermittent is you can take a little here and a little there, a little here and a little there, up to 12 weeks in a year. And there's a lot of the little heres and little theres in 12 weeks over the course of a year. Under the Family First Coronavirus Relief Act, this emergency paid sick leave and expanded FMLA leave, if the school, it can only take intermittent leave under this provision if the school or child care or place of care is closed and the employee is working remotely, and then the employer can allow them to take that leave intermittently, but they don't have to. So it's really up to the employer. Do you want to let them take it intermittently or not? Otherwise, the leave has to be taken continuously. So in other words, it starts on day one and they need 2 weeks of this leave, so they take it continuously for 2 weeks. But later, if they need some more time, let's say they have another triggering event, and it's the very real possibility that you'll have one employee that will have multiple triggering events over the course of this year. So for right now, you might have somebody who's taking this leave because their child is home because the school's closed. Well, let's say 2 or 3 months from now, they get quarantined or they get COVID. Well, they can take it again up to the cap of the 12 weeks through the end of the year. Now, if you have an employee, now this expanded FMLA leave that we've talked about, it's not an additional 12 weeks on top of their pre-existing FMLA 12-week bucket. If they've already exhausted their FMLA leave and they've taken all 12 weeks earlier this year, then they don't get another 12 weeks here. It's still out of that same FMLA bucket for the expanded FMLA leave. Now, the emergency paid sick leave, that 2 weeks, that's a different leave, but that's a different bucket of leave. So you can see this all sounds pretty simple, but then you start asking questions, and then you start facing real life circumstances. What do we do here? What do we do there? It starts getting a little complicated.
Yeah. I think I had a client ask the question about, once someone takes their emergency paid sick leave, those 80 hours for any of those 1 through 6, that's all they get.
Right.
They don't get, say, okay, well, I was, number 1, I was under number 1 first, and I've taken, 2 weeks, and now I'm number 4. That, once the 80 hours are over, the 80 hours are over.
For whatever
for that.
reason.
Right.
Yeah.
Okay, so there's been a lot of questions from our clients for the small business exemption. So we're going to try to clear that up today, because I think there's been some confusion over that with a lot of my smaller clients. So what the guidance now says, the DOL guidance says, is that this is a self-certification, meaning the business owner can make this certification. They need to document this determination, and then they need to retain it. And they reminded us, don't go ahead and send this to the Department of Labor yet. I think they've got a lot going on.
Right.
But so for fewer than 50 employees, you can be exempt for 2 reasons, or 2 things, I guess, under both of these these laws, okay? So from the requirement to provide expanded FMLA leave, which remember is only for the closure of schools, to take care of your child for the closure of schools, or paid sick leave due to number 5. Remember, number 5 is a school or childcare closing. So if you are an employer with under 50 employees, you can essentially exempt your business from providing any of this for an employee who needs to stay at home to take care of their child while their school is closed, so long as you can determine 1 through 3 here. So 1 through 3 says the leave would cause the company's expenses and financial obligations to exceed available business revenues and cause the small business to cease operating at a minimal capacity, or, I guess I said 1 through 3, but it's 1, 2, or 3. Or the absence of the employee requesting the leave would put the company's operational or financial health at risk because of the employee's specialized skills, or there are not enough employees with the requisite skills who are available to perform the work that the employee performs.
So basically, A, we don't have enough money to provide this paid leave, or B, this person is so critical to our operations that we can't do without them. So think CFO or CIO or somebody like that. Or, this group of employees that this person is in, are so critical to our operations that we can't function without them. And I've never seen anything like this in legislation before, where the employer self-certifies this. So, you can essentially exempt yourself as long as you're willing to make these statements under oath and record that and keep it there in case the Department of Labor wants to audit you later about this. Now, I'll add this. We've done this, the government's done this in very quick and I'd say somewhat haphazard fashion. We've got a lot of unintended consequences from this bill and some of the unemployment enhancements that are out there. But there will be a time when the piper has to be paid. The government will come back and start auditing people. So I would not go into self-certifying yourself as exempt haphazardly. You really need to make sure that you can make these types of representations in good faith, because it can come back to bite you.
Yeah, so I've had clients tell me, well, I'm such a small business. I have 10, 15 employees, and this person is the only person that performs that job. I say, well, you probably fit number 3 here. There's not enough employees who perform this job to allow us to continue working.
Yep.
That's the sort of thing that I think you can easily argue. There's one person who does this job. If that one person is out, what am I going to do? I have to hire someone else.
And there's a couple of other exemptions that are really important in this bill. So healthcare workers, and it's basically anybody connected with the healthcare industry is exempt from providing this leave, including their contractors. Technically, just by the way, Brooke and I are both healthcare workers by this definition. I know it doesn't look like it. I'm sitting here in a tie and all that, but we have contracts. We provide services to healthcare entities. So by definition here, we're healthcare workers. We would be exempt if that's the position that somebody wanted to take. Emergency responders, of course, are exempt. Those are essentially law enforcement, fire departments, and then, of course, ambulance drivers and those types of folks. When this bill was first passed, it was really unclear whether these folks would be exempt or not, because there's an existing regulation under FMLA that defines healthcare workers very narrowly to essentially be doctors and
like direct healthcare providers.
Direct healthcare providers, certified nurses and things like that. Not all the way down to like CNAs and people that work in doctors' offices at the front desk and everything. But it became clear that we were going to have to do that in order to keep the healthcare system flowing and being able to serve people who got COVID. So these rather expansive regulations are really guidance. This rather expansive guidance came out from the DOL, which was helpful, provided some clarity.
All right, so next we're going to talk about, I think this is our client's favorite topic, is what documentation can we require from an employee when they call to tell us that they need to be off to be quarantined or to take care of their child. So the Department of Labor guidance tells us that the employee has to provide their name, their dates of leave, the reason for their leave, and an oral or written statement that the employee is unable to work because of the qualifying reason, one of those reasons that we've talked about. They also have to include, if it was a quarantine by the government, who is the one who quarantined them. If it was a quarantine by their healthcare provider, name the healthcare provider. If caring for someone who's quarantined, let us know who that person is and what their relationship is. If for a school closure, they have to provide the name of the child, the name of the school or child care provider, and a representation that no suitable person would be caring for the child. And I think that's obviously to prevent a situation where you've got a husband and wife both, using the situation to stay home. And then if the child is over 14, they have to provide special circumstances. Why does your employee need to stay at home with your child that's over 14? So I definitely think, looking at this is what the minimum amount of information that you can ask for. But I think that Tom and I have been taking the position that if an employee tells you that they've been quarantined by their healthcare provider or that they've received a coronavirus diagnosis, that you want a copy of that you want a doctor's note, essentially.
At some point. Certainly if you've got somebody who said, I've got COVID, you don't want them coming to work.
Yeah.
You get this documentation, the minimum that's required here, then you might want to ask them for something that's from the healthcare provider or from the government that verifies the quarantine or the diagnosis at some later point, maybe before they return back to work. But this is at a minimum what you have to collect. And the reason you have to collect it at a minimum is that, we talk about this in just a second, it has to do with the tax credits and the ability to get the tax credits. And this is largely a self-certification from your employee. And it's best to collect this information in writing. Obviously, we have provided forms for clients to use to collect this information from the employee. And they sign at the bottom, they declare under penalty of perjury that what the information they're providing is true. We've also included a warning about what happens if you provide false information, because there's been there's been issues or problems or challenges on both sides here. On one hand, you got some employees who are wanting to come to work who maybe shouldn't. They're having some symptoms, but they're passing it off, and they're not telling anybody because they want to come to work and get paid. On the other hand, you got some employees who are just scared to death. They don't want to come to work. They want to stay locked up at their house. So they're trying to figure out how not to come to work. So you're dealing with both of those types of challenges right now. But you got this self-certification process, essentially, where an employee fills out the form, and as long as they're willing to provide this minimum amount of information and swear that that's true, they get to leave. But I've been advising people, if you want to, you can ask for the actual underlying document, the diagnosis or the quarantine order. Now, here's the part about the tax credit. So, largely, this expanded FMLA leave and this emergency paid sick leave is largely being paid for by the government. It's not free. We're all going to pay for it at some point. But for now, the government will pay the employer the cost of the minimally required leave via payroll tax credits. And it's a refundable tax credit, which is, I'm not a tax lawyer.
Yeah.
Best I did in taxes, I took it, first year at Alabama. After that, I haven't really dealt with it. But I do know a refundable tax credit is the best thing in tax law. So you get that paid back to you. You don't just carry it over to the next year. And it includes not just the wages that you spend, but also qualified health plan expenses, so essentially what you pay to maintain health care coverage and the Medicare tax. And you can withhold on your quarterly tax payments the federal income tax withheld from employees, employee, employer share of Social Security, Medicare taxes, up to the amount that you've paid for the leave. And if the amount that you've paid for the leave somehow exceeds what you would pay that quarter in employer taxes, what you would have remitted to the government, then you can submit a form, this Form 7200, to get an advance payment of employer credit. So that's how it gets refunded back to you. So you have to keep the documentation that the IRS is requiring you to keep. And by the way, this guidance comes from the IRS, not the DOL. You got to keep the Form 7200s, the Form 941s, which of course you're doing that anyway. That's your normal quarterly federal tax return. And the documentation that we just talked about, the self-certification from the employee about their need for leave. So you have to have that amount of information on file, and you need to have records that shows how you determine how much you paid them, how much they worked, which you're going to have that anyway, hopefully, to comply with Fair Labor Standards Act. And so that when you get audited, or if you get audited, because on the back end of this, remember, everybody's going to pay the piper at some point for this stuff. In the next year or 2 or 3, you might get audited by the IRS, and you might be required to prove the claims for tax credits that you made, and you need to have this documentation available, or else those tax credits may be taken away from you, and there may be fines and penalties. And I hope that I'm wrong about this, but I suspect that there is right now, as we speak, some amount of fraud going on with respect to leave being provided. In other words, there may be some folks out there making claims for tax credits for leave that they haven't actually provided. I hope that's not the case, but as a lawyer, I suspect that that's going on. I hope it's not anybody on this call.
All right. So also in this this new legislation is a no retaliation provision, which states that it's unlawful for an employer to take action against an employee because that employee took the paid sick leave or engaged in other legally protected activity. A failure to provide the sick leave is going to be treated as a violation of the Fair Labor Standards Act. Interference and retaliation are unlawful, as they are under the normal FMLA. I guess what an employee would have to do if they are employed by someone who has less than 50 employees is they would have to file an administrative complaint with the Department of Labor if they wanted to argue this.
Now, interestingly, these two pieces of leave can be enforced by the employee. So the emergency paid sick leave the enforcement provisions are tied to the Fair Labor Standards Act. The expanded FMLA leave enforcement is tied to the FMLA. So bottom line, an employee can file a lawsuit tomorrow over a violation of these laws and go straight to federal court without filing a charge of discrimination or anything with the EEOC that some of you may be familiar with. So there's a lot of private enforcement built into this law. And I suspect we're going to see a lot of litigation over employer compliance with these laws because they've been thrust upon people so quickly without a lot of guidance. There's going to be employers out there making mistakes, and there's going to be litigation about this. Now, one thing you might want to check is make sure if you've got EPLI insurance, you might want to call your agent or broker and say, hey, if I get hit with one of these claims, is this going to be covered or not? And I'm not sure you're going to get an answer that you like with this being a new piece of law that's out there that wasn't in place when your policy was bound, but you might want to find out now as opposed to later.
But in addition to litigation over that particular law, the Coronavirus Response Act is these other areas of the law that we've got to think about. The ADA, other parts of the FLSA that we're going to talk about in a few minutes that are brought up by the fact that people are teleworking. I just read an article, I think Constangi, our law firm, put out an article about what they're calling the first litigation that's come from this as far as an employer perspective is that employees or families of employees have sued Walmart, saying that their family member had to go to work and they were exposed to the coronavirus and got the coronavirus, got COVID-19 and died. And so they have sued Walmart because of that. And they've said, Walmart didn't do enough to clean. Walmart didn't do enough to change their hours. Walmart didn't make all of these changes that they needed to make for their employees. So we just got a lot of, litigation concerns from our clients.
So the other federal laws and state laws, for that matter, that dealt with employment, they've not gone away. They haven't been totally replaced with the FFCRA. So you got to make sure you're still complying with the existing laws. So, for example, COBRA, if you lay somebody off or furlough and their hours drop, you may have to give them notice of their right to continue their health care insurance under COBRA. Certainly FMLA, the rest of it's still in play. The ADA, there's going to be a lot of concerns about the Americans with Disabilities Act, particularly as people start coming back to work. The Fair Labor Standards Act, that we're going to touch on a little bit, that deals with how you pay employees. The Warren Act, National Labor Relations Act, unions are using this as an opportunity to try to attack companies and maybe rally employees to their cause if employers are not being careful about how they about the things they do to try to protect employees' health. And we'll talk briefly about the OSHA recording requirement in just a second. So I won't dwell on this too long. The WARN Act is typically a federal law that requires employers to provide advance notice, at least 60 days advance notice, of a plant closing or a mass layoff. There's an exception in there for natural disasters, which employers seem to be taking advantage of, meaning that if something unexpected happens, you can give less notice. So over the last 4 to 6 weeks, you've seen plants closed, people laid off en masse, and employers are giving as much notice as they can, claiming this exemption. So if you're in a position where you're doing that, give as much notice as you can. I think you'll be okay. In fact, even California suspended the application of their state WARN Act equivalent back at the end of March, because essentially everybody knows if you're going to have to lay off folks because of this sudden change in business environment, you really don't have time to give 60 days advance notice.
So similar to that is, questions that our clients have had about whether you have to pay employees who are sent home due to business decline. I hope that we're getting past that issue and that now we're hopefully working with our clients on bringing employees back, but this has definitely been a question about whether employees have to be paid. So for this question, you really need to look at the Fair Labor Standards Act and then any specific state laws that are in, your state. But for hourly non-exempt employees are only paid for the hours that they actually work. So generally, you do not have to pay your hourly non-exempt employees if they're not working. If you send them home because there's no work for them to do, you don't have to pay them. Exempt salaried employees generally have to receive their full salary for any week that they perform work. So I've had clients have questions about, well, I kind of need them for a day or two, but I really don't need them every day, every week. Well, we have to look at the Fair Labor Standards Act and figure out, if this is a salaried exempt employee, you've got to pay them their whole entire week's salary if they provide any work.
And what you may have to do in that situation, if you need them for some of the week, but not all of the week, as opposed to dealing with the FLSA here, you may just have to have a salary cut in place and change their salary. You make sure you do that prospectively for a full week. I wouldn't do it in the middle of the week. I think you end up with breach of contract claims with that, but you may end up having to do a salary cut for a period of time. Teleworking and hazard pay. So you've got a lot of employees out there who are working from home for the first time ever, and they're used to the normal come to the office, punch the time clock, go to work, punch out for lunch, punch back in, and then punch back out at the end of the day. Now, all of a sudden, their day is just one big mishmash of dealing with stuff at the house and working. And a lot of people have been doing that for a long time, but if you have not been familiar with that, if you're an employee that's not familiar with that, you probably need some training on how to accurately record your hours worked, because recording hours worked is ultimately not the responsibility of the employee. It's the responsibility of the employer to make sure that there's a method for accurately tracking hours worked. So you might want to engage in some training of employees, telling them, make sure they understand what's hours worked, what's not, the minimum 30-minute meal break rule. So in other words, for a meal break to be deductible, they have to have 30 continuous minutes free from work. If you're emailing your hourly administrative assistant at 9 o'clock at night saying you need some project done and it lands in your email inbox at 8 o'clock the next morning, you might want to follow back up with that person and let them know you need to make sure that you track that time that you spent last night working on that, because there are going to be some FLSA lawsuits, Fair Labor Standards Act lawsuits that come out of this on the back end. And if you don't have an online time clock where people can report their hours worked remotely, you at least need to have people creating paper records of the hours they work and turning that in and letting that get entered into the system. And a brief note on hazard pay. So there's a lot of employers who are paying extra, either bonuses, shift bonuses, weekly bonuses, or just extra hourly rate, $1 or $2 more an hour to incentivize employees to come to work. That's all well and good, and I would encourage it if you're in a position to be able to do that, but you need to absolutely make sure that it gets included in the regular rate for overtime purposes. Even if it's, say, $200 extra a week as a hazard pay bonus, there's a method to calculate that, to take that bonus and calculate it back into an equivalent hourly rate for overtime purposes. If you don't pay overtime for that, you are going to likely get hit with a DOL complaint or an audit or an employee lawsuit at some later date saying that you did not properly pay overtime. And you'd rather get that handled now as opposed to when you get hit with a private lawsuit. Because in the private lawsuit, their attorney you pay their attorney their fees. If you have any questions about that, feel free to contact Brooke and I. We're very familiar with that process.
Okay, so we've talked about the Department of Labor has put out a lot of guidance about this new Coronavirus Act, but the EEOC has put out their own guidance to tell us how to deal with the laws that they were already, covering, such as the ADA. So one question was, how much information can an employer request from an employee who calls in sick so that they can protect the rest of their workforce? So what the EEOC said is that during a pandemic, the ADA covered employers, so that ADA covered employers or anyone who has more than 15 employees, may ask the employee if they are experiencing symptoms. And the EEOC, this guidance listed, these particular symptoms. As the CDC comes out with, more symptoms, we will be, I'm sure the EEOC will be adding that. Employers must maintain all of this information about employee illness as a confidential medical record in compliance with the ADA. So that's something that you absolutely need to be remembering, that you're not telling the rest of your employees what, is happening with an employee who is out, and that you're maintaining those documents in a separate file.
Put them in their usual medical file.
So when may an ADA covered employer take the body temperature of employees during the COVID-19 pandemic? So normally employers would not be allowed to take the temperature of their employees. That would be considered a medical examination. But because of everything that's going on, the CDC is talking about the community spread, employers may measure employees' body temperature. However, employers should be aware that some people with COVID-19 do not have a fever. So that may not be the final answer.
Does the ADA allow employers to require employees to stay home? Of course, they do. If you have employees who are showing symptoms, they can stay home. You don't want them to come to work. And can you require a doctor's note certifying their fitness for duty? Yes. There's a lot of things now, just because of the this current crisis, that normally under ADA, if you're an HR manager, you'd be going, oh no, we're not taking employees' temperatures. We're not asking employees if they have these symptoms. Well, the cooler heads at the EEOC have prevailed and realized, we need to lighten up on this and let employers take some precautions to make sure that their workplace doesn't turn into a hotbed of COVID. And that has been a real problem in some industries, as you've probably seen in the last couple of weeks. The meat packing industry is being besieged with a lot of COVID illnesses because employees in those industries work so closely together, shoulder to shoulder. And it's a real problem. You got to take some steps to try to screen out employees as best you can. I'm a little concerned there's no real effective screening for this, but you got to try to do something.
I think another issue with my clients are wanting to make sure that when someone returns to work, that they have a return to work form, something that says that they are no longer contagious, that they no longer have the virus. But because all of our healthcare providers are so busy and so inundated with other with patients and things like that in some areas, then how are you going to be able to get a doctor's note? In normal cases, we would likely tell our clients, don't accept an email. We don't know where that email came from, but today we probably tell them, if if there's an email from a at UAB email address, you probably just need to accept it, because that's likely all the employee is going to be able to get
for a little while. For sure.
Yeah. So we have some common questions under the ADA. So is fear of exposure a disability? I cannot tell you how many clients have called and said, I have an employee who doesn't want to come to work because they're scared they're going to get coronavirus because of certain, industries that they're in. So is that a disability? Probably not standing alone, but it's going to depend on the individual's particular health situation and any, complications. So for example, if an individual has a mental impairment or some sort of other physical disease that would be exacerbated by coronavirus, then we may have to look at it as an ADA situation.
Essentially, do what you can to make employees feel comfortable. If somebody says, look, I'm scared about this, maybe allow them to work with a mask, which is probably may become required here soon. We're not sure. Work with their door closed, maybe limit traffic, some things to help make them feel comfortable. But ultimately, unless they've got a disability that makes them more susceptible, which you could perhaps even accommodate without letting them just go home, just mere fear that they're going to get it is not going to be sufficient for them just to not come to work.
I'm gonna skip just a few of these. Just wanted to talk briefly, are there workers' compensation concerns? So potentially there is, if an employee contracts the coronavirus while they're at work even, are we going to get workers' comp claims?
Yeah, it's kind of up in the air. I've talked to some workers' comp carriers about this, and they, for the most part, they haven't really decided whether they're going to accept these claims or not.
Yeah.
From an employer standpoint, you might want them to take the claims because workers' comp exclusivity is a powerful thing. If an employee, gets sick at work, or they think they can trace it to work, or unfortunately if they pass away due to getting COVID at work, you might rather have that be a workers' comp claim as opposed to a negligence claim.
Well, that employee, that Walmart case.
Yeah, that Walmart case is a prime example.
Yeah, you would, and Walmart would much prefer that be a workers' comp case than a negligence case.
Right.
Absolutely. You want to get OSHA real quick?
Yeah, well, just touch briefly on this OSHA recording requirement. So, and I'll touch on this as well. You have to provide masks or gloves. So this is what we talked about, or what Brooke alluded to earlier. Initially, the CDC wasn't recommending that healthy people wear these masks, but now they've changed and said, well, they're going to recommend cloth face coverings in public settings where social distancing is difficult to maintain, but not N95 respirators or surgical masks. The main reason for that is they want to make sure that stockpile of surgical masks and respirators are available to healthcare workers. But they are recommending cloth face coverings in public, which you've probably seen a lot of that last couple of weeks. So you're likely to see employees show up at work with this sort of stuff. My recommendation is for you to allow them to do that. And normally you might not let your employees show up to work with a mask on. For the time being, I suggest you roll with it and let that occur. OSHA recordability. So normally, if you have an employee who has a occupational disease, they get it at work, you've got to record that on your log. OSHA recently released some guidance that essentially said most employers, and when I say most employers, meaning not healthcare employers, not emergency care responders, you don't really have to investigate the source of the COVID. If you have an employee that says they've got COVID, you don't have to go around trying to play Inspector Clouseau and figure out whether they got it at work or somewhere else. Unless there's clear evidence essentially that has fallen into your lap, the employee tells you that they got it at work, or that you had a cluster outbreak at your place of business. Short of that, you don't have to record it. Now, if you're a healthcare worker, or in the healthcare industry, an emergency responder, you need to do your normal due diligence and take some steps to figure out whether that exposure happened at work or not. And there's whistleblower protection in OSHA. So if you have employees who are complaining that you're not doing enough to protect employees from COVID, they may and probably will be protected by the OSH Act retaliation provision. So, even if you have some employee who maybe you feel like is unreasonably questioning what you're doing to protect themselves and other employees, you got to make sure that you don't retaliate against them for taking those steps. And then I think we're going to wrap up with some discussion about unemployment claims. So as of April 20, and I looked this morning to see if the ADOL has updated any of this data, and I didn't see anything. So this is actually about a week old now. As of then, they had paid $164 million in benefits to 103,000 claimants. And most of that, $132 million of that, came from the federal unemployment compensation. That's the extra $600 per week federal enhancement. And as some of you may have found out, if you have an employee who qualifies for that state $275 per week, then they automatically get that $600 per week extra. And that works out to, for employees that work 40 hours a week, that works out to about $21.88 per hour in unemployment comp. There's a lot of employees out there in the state of Alabama who don't make $21.88 an hour working. But these benefits are not capped by the employee's earnings while working. It's up. They get the $875, and it's intended to be that way. So you have employees right now, and there's a lot of them who are at home on unemployment, making more money not working than they did when they were working, and it's going to cause some issues. Already has caused some issues. For example, I've had clients whose employees who weren't making $875 a week went to their boss and said, pretty please, would you lay me off? Yeah. I don't want to come to work. I don't want to be exposed to the public, and I can make more if not working for you.
Right.
And then now we're about to have a situation where employees are going to be called back to work, probably starting May the 1st, and shortly thereafterwards. It's going to be, I'm not exactly sure what it's going to look like, but it's going to be a phased-in process. So you're going to have employees being started called back to work over the next few weeks, and they're not going to want to come because they're at home making more than they used to. And that's going to cause a real issue. And in fact, the ADOL issued a release last Thursday that made national news, essentially warning employees, when you get called back to work, you need to get back to work, because if you keep claiming unemployment benefits, you might get in trouble for unemployment benefit fraud. So stop.
So we wanted you to take a look at this table of unemployment claims. We have been on webinars with the Alabama Department of Labor talking about the fact that they are increasing so much from last year. Like, for example, in 1 month, there had been more claims with the Alabama Department of Labor, actually 3 times more claims in 1 month that had happened all of last year. So the Alabama Department of Labor has the same amount of people trying to fulfill these claims. I had a client call last week and say, I am doing everything I was supposed to do. My employees are not getting any of their money. Well, you can see right here, it's taking up to 21 days. And this client had said, I've started doing this 3 weeks ago. And I said, well, I think you're doing everything right, but it's just, you're just not getting paid yet. You know, your people aren't getting paid yet. I told them about the claims tracker and to go on there and to make sure that everything's there. And that's really all you can do.
So you can look at those numbers and see you've had over 300,000 claims made in the last few weeks. In all of 2019, the Alabama Department of Labor had about 130,000 claims. So you've had more than double the number of claims for all of 1 year just in the last few weeks. And it's caused a real issue in the administrative processing of the claims. My good friend Fitzgerald Washington, who's down there as the Secretary of the Department of Labor, used to be in Tuscaloosa. He's got his hands full.
Absolutely. So this disqualifications, this is what the Department of Labor put out, last week, letting you know that you will be disqualified if you refuse to return to work, if you refuse to receive full-time pay because you want less, so that you'll be able to get the additional $600. Or if you quit work without good, work-related cause. I've had clients call and say, the employees are asking me, can I quit now? And then will you hire me back later? So
now, interestingly, most of the time, employees can't just refuse to come back or quit because they have child care issues. But for the near future, there's a lot of things that have changed in the unemployment benefits claims. There's a lot of things that used to apply that really don't anymore. You've got gig workers and independent contractors and self-employed people suddenly eligible for unemployment benefits claims. And there's a lot of these employees who are out who will probably still be able to draw unemployment for quote unquote, not working or not going back to work for good cause, because they're still home, needed to provide care for high-risk family members or somebody who's got COVID, or just because they still have kids at home because of school closure or child care closure, at least through the end of the normal school year, which is about another month or so. So you could very well see in the next few weeks, as people are recalled back to work, they go, look, I can't come back to work. I got kids here at the house. I got to be here. And normally you would say, well, that means you're not going to get unemployment. Well, not now. It seems pretty likely that they'll be able to continue to draw unemployment. So, for those of you who are employers on this call, I'm going to make a prediction to you. You're going to have a very tough time getting people back to work over the next few weeks as you're able to ramp back up.
So that is the end of our presentation. So you're welcome to email us or call us and ask us questions. We'll help you out any way that we can.
Well, thank you. And with that, I'll turn it over to Ashley Page.
All right. Thank you, Tom. Good morning. Felicia, sound good? Coming through okay? Good. Thank you. Well, first of all, let me say we're delighted to be with you this morning. As Tom said earlier, we know that you've got a lot to do on a Monday morning, so we appreciate you spending that with us. My part in companion with Tom and Brooke and Constangy, Jay McGowan, who is also in the presentation, is our Director of Financial Planning. Jay's going to come up in a minute with more of the individual side of the CARES Act. But I'm going to take sort of the owner-managed business corporate side. The reason for that, I'm in my 11th year on the portfolio team at Five Plan Partners, but I also direct our owner-managed business consulting unit. We're a very holistic wealth management firm, and we do that because, like in the state of Alabama, there are so many owner-managed businesses out there, and so many of our clients have both wealth in markets and they have wealth in their own businesses at the same time, or like we anecdotally say, their business is their growth stock. So Felicia has popped up the first slide on the SBA loan. Before we get into that, I will say, it always, I don't know how it is with y'all, but it always helps me before I kind of get in the rules of things, is to step back from it a little bit and go, why are we doing it this way? Why are we aiming the Payroll Protection Act at individual employment? That seems to be a lot of it and very new. That's number one. Question number two is, why are we using the Small Business Administration, or SBA, to do it? And three, long-term, what we're trying to accomplish. So let me give you the quick answers to those three. Number one, from a theme point of view, what we're trying to look at is simply this. When I'll take you back in a time machine just for a second to 2008. You know, the last time we put this much stimulus into an economy like we did was back in 2008. Now, it was orders of magnitude less then than it is now, because what we're talking about now is a total shutdown of the economy. What we were talking about then was just, if you remember the TARP program, we had problems with subprime mortgages. So what we aimed back in 2008, our stimulus at, and what it is the same, is a combination of both the Treasury and the Federal Reserve back then. It's the Treasury and Federal Reserve now, but it's much, much bigger. But Jay and I will both tell you that because the 2008 financial crisis is enough in our rearview mirror, academics have been able to study that. Fed and Treasury officials have kind of gone back to 2008 and gone, okay, what worked well in 2008 that we can apply? And the simple answer is, almost to a woman and man, of the interviews I've read, or interviews I've seen, interviews I've read, when you get right down to it, both Treasury and Fed officials said, you know, if we had to do the 2008 stimulus over again, the first thing we would do is make it broader beyond subprime mortgages. And the second thing that we would do, and this is the most important for you all to understand, we would aim it a lot more at employment, because at Five Plan, what we looked at, we followed vast amounts of data every day. But what we noticed when we kind of came out of the backside of the financial crisis, this was like 2010, 2011, when things really started to stabilize, that the unemployment rate was still really stubborn to move it back down. And it wasn't really until about 2016 that it started to get normalized again. So the first thing that you're seeing with that is that you're seeing federal officials, mainly in the Treasury and the Federal Reserve, learning from 2008, the financial crisis, and they're aiming a lot more of this stimulus to keeping people employed, because they realized after the 2008 financial crisis, what happened was we had a lot of people that got on unemployment rolls and we never really got them back. So this time, the one lesson that we got from 2008 as an overall theme is, let's make sure that we come out of the backside with a lot more people employed. The reason that's important, y'all, is this. 70% of our gross domestic product, and therefore financial markets, are driven by consumer and consumer spending. So what makes consumer spending go and the markets be good? People having a job, being confident in that job, and going out and spending. That's where it comes from. So that's the main reason thematically we're aiming a lot more of this SBA stimulus at employment. We learned that from 2008. The second question that I pose to you is, why are we using the SBA to do this? Couldn't we use another agency? The simple matter is, we had to get all of this funding out into owner-managed business hands very, very quickly. And the simple answer is, the Small Business Administration was already set up. We already had an execution mechanism that we could use. And you've heard some horror stories on it when you look at that. And we'll talk about a few of those in a minute as we go through this. But the truth of the matter is that would have been a whole lot worse if you would have had to put the care funds out there in way of stimulus, and then on the back side of it, invent an execution program. That could have taken months and months and maybe years. So if you look, finally, 3 is what are you trying to accomplish? I heard an interview yesterday with Treasury Secretary Mnuchin, and he said simply this: we've had 2 rounds of this now. The first round put $350 billion with a B in the owner-managed business circulation in the United States. That was first phase. We ran out of that in about 13 days. It assisted about 1.7 million businesses. About 5,000 financial institutions participated, and the average loan size was a little less than $200,000. So you can deduce from that it really was aimed at use of payroll. Now, what's interesting today is, as we speak, the second round today has started. That's $310 billion. As I say, the first round was out in 13 days. As we say in our office, the good news is the first round was out of money in 13 days. The bad news is it was out of money in 13 days. But it proved itself getting money into the system so quickly, you all, between 13 days, that the mechanism, even though it was a little bit chaotic, it did work. And with this second round, Jay and I were talking about it the other day, with this second round of $310 billion, that will probably be faster than 13 days because, simply put, there were a lot of people in line with their lender right at the end on the first round when funding ran out, and they're just going to hit the send button. I mean, they were set up ready to go, and now that the funding has been passed, you're going to get an initial wave coming through that pushes that up. So the long and short of it is what we're trying to do. What we should accomplish with this between both rounds is that the first round was roughly 25 to 30 million in jobs saved. The second round will be equal to that. So if you add it all up, it should be 50 to 60 million jobs saved. Now, here's the important thing, and if you remember nothing else, that is 50% or half of the private employment in the United States, not public firm employment, not university employment. It's like the Ashley Page tool and die that's got 35 people. It's that type of employment. But if we can get this through the system with the second round, despite some of the up and down that we've had with it, what we're going to find with that is that we're probably going to have kept on the payroll about 50% of private employment in the country. That would be a huge advantage coming out of the back of the pandemic on that side. Felicia has popped up this second screen that we had right before. Again, we're using the SBA because they've been around for years. The SBA goes back to its initial formation in the Dwight Eisenhower administration. Thank you, Felicia. And before my time at Five Plan, I was a commercial lender for many years in banks here in Birmingham. And these three loan programs that you see on the screen, they've been around for years. This is nothing new. And let me tell you how the payroll protection is getting into the system. The SBA 504 loan, they're not really using that at all. The only reason I put that up is that's for owner-managed business financing, and just for sake of completeness beyond this, I wanted y'all to know that that was out there. But there's some unique funding issues with a 504 loan that take longer than the last two. That's why we're not using that. What we're doing for a payroll protection program is that we are using the last two. We're using the SBA disaster loan. Now that is a loan straight to the SBA. That is funds issued straight from the SBA. The second loan program, the SBA 7A loan, or this is my terminology that Jay and I use. We're sort of calling it among our clients the enhanced 7A program. That's been around for years. Now the way that is working, Those are the loans, y'all, where you go to your bank or a credit union lender or other type of lender. And what happens is the SBA comes underneath your bank loan with a guarantee. So the first confusion we had in this is that people justifiably were getting twisted around the axle between the two. The SBA disaster loan was smaller. It's got a maximum of $2 million on funding. The SBA 7A loan is much larger. The maximum of that is $10 million in funding. And people, and understandably, people were getting sort of the rules confused. As a former banker who used them both, even I had to go back along with Jay, and he will tell you we had to go, okay, is this disaster loan rule? Is this SBA 7A loan rule? But it's loans 2 and 3 that are the main way that payroll protection is working, mostly the latter. So Felicia, if we can go to the next slide, please, ma'am. The first one we're going to look at, I'm not going to spend as much time on the disaster loan, y'all, because that one was smaller. This was the first one that came out that could be used by the state of Alabama and businesses there. And simply put, the disaster loans, again, have been around for years, but it's not like the name suggested. They were for tornadoes like we had a couple of weeks ago if a building was destroyed. I'm a Baldwin County native. It's hurricanes down there. It's flood and fire. And they've been used for years for that. Right off the bat, what the Treasury did through the SBA is they just opened that up where coronavirus or COVID-19 was a disaster. So you had a lot of people, they took the program they already had and smartly, in my mind, just expanded it. So Felicia, next slide on that, please, ma'am. And the thing about the disaster loans is they're a little bit broader because they're smaller and how you can use them. You can use them to pay fixed debts. You can use them for payroll, but you don't have the restrictions on the percentage of how that's applied. You can use it for accounts payable, and you can use it for other bills. You can use it for your rent on your building, your utilities, even down to the level of paying the FedEx person that's shipping your product. So on the next screen that you will see, thank you, Felicia, those loans, as we said, are up to $2 million. And this is a point whether you're either using the payroll protection or maybe you have a client who does. It's up to $2 million. These were the smaller loans, but it's minus business interruption insurance you already have. So that makes plenty of sense. If you already had business interruption insurance that covered this, and pandemic is something is included in a lot of standard policies, the government still will allow you to apply for a disaster loan, but after that $2 million total, you do have to subtract off any business interruption insurance you have. Makes sense. The government doesn't want you double dipping. From a rate point of view, these are very, very favorable loans. You can get the amortization on some of these up to 30 years. And you all look at the rate, it's 3.75% for for-profit businesses, 2.75% for nonprofits. So the amortization rate's very favorable. So Felicia, next one. The other thing you saw on that one is the disaster loan is the one where you could get an advance up to $10,000 over a certain regulation. That's the thing that is in all these loan programs that's really a grant. With that initial $10,000, if you follow the rules on the disaster loan, you do not have to pay that back. So that was a quick way to get at it. In addition to having disaster loan, what the federal government also did on disaster loan is they really shrunk down both the way and what you needed to apply and how quickly the money got there. So as Felicia is showing you here, the main thing you had to have was 3 years of your most recent federal income tax returns to show historically how you were doing, an interim profit and loss statement. Felicia, the next one. You also had to show your current schedule of liabilities, fill out a personal financial statement, and then also, too, you had to pledge collateral if it was available. They were a little bit more lenient on that. But here's the most important thing to remember on the disaster loans. Really what they wanted you to show is a sales level kind of on your trailing 12 months. So in that case would have been like March 2019 to March 2020. The government wanted a picture there of kind of how your sales level looked before the pandemic and after. How did your sales level look? How did your net income look? So a lot of people had to put that together. That was one of the major forms you had to fill out. And then look at the cut at the end of March and then into April. Now that's the way the disaster loan worked. We're going in now to the 7A loans. This is the bigger one. But remember, the disaster loans are smaller, about 2 million, much more wide in application. Jay and I will tell you that for 5 or 6 weeks there, we were drinking out of a fire hose with all the different type of fact patterns that we had. And we had both clients and friends and prospects doing a little bit of all of it. It was some disaster loan. Most of it was using the 7A process because it was larger, more long-term. Some people were in good enough shape where they didn't really feel like they wanted to fool with it and have either. But the main thing to remember on payroll protection is the SBA 7A loans. This is the main one that is being used. When I did that in my previous career, a banker used these all the time. And these are the main things I did with it, as opposed to the 504 that was real estate. I was trying to help a company with their working capital. I was trying to help a company with their term debt. So Felicia, go to the next slide. However, I'm doing compare and contrast of that. You never historically used a 7A loan just strictly for payroll, because back in the 80s when I got law school at Alabama and I was being trained as a baby commercial lender, as you will, one of the warning signs we were always taught in lending to an owner-managed business, look, if they're coming to you to borrow fairly regularly for payroll, you've got a problem there with the quality of the credit, because they should be able, within their operating system, to pay their payroll. What's interesting for bankers this time is that's turning that upside down. And not only are they saying you can use it for payroll, guess what? That's what we mostly want you using it for. So under this part of the Payroll Protection Act, you're required to use 75% for payroll. You can use 25% of it for those other issues, the rent, utilities, that type of thing. The original rule, as Brooke was saying on their part the other day, Jay and I saw this constantly changing as we were going through it. And I'll give you just one note of warning there. It's the SBA and your lender that will always control. So if you're updating this, you want to make sure you check those rules carefully. But initially that was 10 weeks of payroll. The window now is 8 weeks. And you could get up to 10 million. That was done by formula. So that's the way it originally looked. The main thing that we're running into that is an excellent, excellent part of this is that if you keep your employees on payroll for an 8-week window, in other words, if you've got 25 employees and you're starting now in the Ashley Page Tool and Die, I'm incentivized really to keep them on payroll for at least an 8-week period, because if I do that, I'll get either complete or partial loan forgiveness of that. And if you meet the certain employment conditions, the thing I will warn you about that, if you're on the call and involved with this, is going to be particularly important, just like it is with Brooke and Tom on the labor and employment law side. The key to this, and I couldn't agree with Tom more, you're going to have excellent records on this, because basically people are just thinking, oh, all of the loan is forgiven. No, it's not. That's going to be up to the SBA and the lender, and how good your documentation is on that is really going to control. So you want to make sure that you do an excellent job on your payroll accounting, and you want to make sure that you do an excellent job on the all other accounting to make sure that when you go back in and this 8-week period is up, you can prove that out. Now, we've had some questions that are along the lines of, when does this 8 weeks start to run? And this is the rule that I've read with it. Once you apply for the 7A loan, the SBA has got 10 days to get the funding in your hands. Once they get the funding in your hands, that's when the 8-week of payroll clock starts right there. So that's the window that you're in. But your incentive is if you're in the Ashley Page Tool and Die and you've got those 25 people, you're incentivized to keep them. And you just have to prove it out at the end that you did so. So Felicia, next slide on that, please. The great thing about it is, like with the disaster loan, the one thing that the SBA did on the 7A loan to get a lot of payroll protection out is they really all streamlined this down from what you normally do with a 7A loan. So basically, you really didn't have to have any collateral or personal guarantees on it. And one other point that I'll make to you is that historically, when I did 7A loans as a banker, the SBA would come underneath my loan proceeds and guarantee, we said, to about 75 to 85% level. So I used to love as a banker doing as many as these as I could because they were a good yield on my balance sheet, but I had a safety net of the government underneath. The main reason we used them is we already knew we had a good company, but something maybe from credit and underwriting we needed to shore up. Maybe the loan to value or LTV on the collateral needed to be a little bit better. Maybe fixed charge needed a little bit better. So the interesting thing now that is happening is on the 7A is that on the payroll portion, they are elevating that guarantee up to 100% on a lot of it. So you're having the 75 to 85% on part of it, but that tranche, if you will, as long as you document it properly, that you're doing on the payroll, the SBA is backing you 100%. So that almost for that part of it ends up being a riskless loan for the bank, which is why you saw so many financial institutions jump on it. And before I go to Jay, let me just give you a little bit of postmortem of how this worked. What you saw in the first round, the analogy I'll give you, like Tom and Brooke just said, you're just hitting established government systems with a lot more volume. We've all flown through the Atlanta airport, and it kind of reminds me of that as an analogy. If you got a beautiful day like this going through the Atlanta airport, you can move a ton of people in planes. But if you got a bad weather system over the top of it, it really slows you down. So what happened is you had an existing SBA structure, and along with that, you had a lot of other lenders coming online going, man, this is a good opportunity, and it just slammed the system all at one time. So that first $350 billion that went out, that was a little bit more start and stop because there was just so much volume hitting the system. And I think it's impressive that even with all of that going on, within 13 days, we got that funding out. The other thing we'll talk about a little bit before I end my section is, there was a lot of pushback a little bit on some of the public companies that got this, and I looked at a lot of research on that. Some of those public companies were small, and if you went through the rules, they followed it exactly. The ones that got in trouble were the large publicly traded companies that really didn't need it. And they've tightened that down on this second round of $310 billion. And Secretary Mnuchin has established May 7th as a safe harbor date. And he's basically said, look, you may have followed the rules to the letter, but you violated the spirit of the rules, and you really need to give that money back. So in addition to this $310 billion, if they do it by May 7th, no questions to ask, just return it. But I think if you don't return it past May 7th, I think they're going to put a little bit more scrutiny on you. So in looking at all that, again, we'll summarize. This should come out this week. We would probably be out, my guess would be by about Thursday or Friday, we'll be out of the second round. But the good news is, using the payroll protection program, we're going to have had a massive positive impact on private business employment in the United States. So if this works the way that it should work, we're going to keep a lot of people employed that would have been unemployed. So with that, I'll end the owner-managed business section of that and turn it over to Jay McGowan, who's going to talk to you a little bit of the CARES Act on the individual side. But before he does, I'll tell you, if you've got any further questions about that, feel free to call me anytime, Felicia Ludham on the screen, or Jay. We've worked, not surprisingly, like Brooke and Tom have, we've worked a ton with this recently. So we kind of know a little bit the ins and outs of it, but hopefully at the end, we'll keep the unemployment rate back at the point as opposed to 2008, much more normalized, much faster. So that would be Good. One other quick thing I'll say before Jay comes on. The last question we got is, how are we going to pay for all this? The deficit from March 2019 to March 2020 was $1 trillion, trillion with a T. With all this stimulus going in, that deficit now is up to 3.7 trillion. To give you a historical reference, y'all, that is what it was at the end of World War II, right after the war ended. However, the good news is, if there was any time to do deficit financing with a pandemic, is now, because interest rates are so low that in a fascinating way, the carrying cost for the country on the interest rate is actually less with the long-term rates being negotiated on the 3.7 trillion than it was the prior 1 trillion. So even though it's a much higher deficit amount in absolute terms, the carrying cost is less. We just need to get through it and get on the other side where the tax revenue, it gets back to the government and we can reduce it back. So with that, I'll turn it over to Jay McGowan, our Director of Financial Planning.
Good morning, everyone. I really appreciate the time and taking time out of your busy days. I know Monday morning is a hard time to devote this time to anything but taking care of business. So I really appreciate it. Like Ashley said, what I want to do with my time is kind of focus on some of the individual provisions or the provisions in the CARES Act that apply to individuals. It's a 900-page piece of legislation, so there's a lot of information, a lot of detail in it. But I just wanted to touch on the highlights. I know we're getting towards 11:30, so I'm going to try to work my way through this pretty quickly. But the first thing I want to talk about is the recovery rebates for individuals. So that basically this is the cash payments that you've been hearing about that everybody is waiting to receive in the mail. And so what these are refundable 2020 tax credits based on your 2018 or 2019 adjusted gross income. And so basically what it is they're going to take the tax return that you most recently filed, and they're going to look and say, okay, how much of a refund or refundable tax credit do you get based on 2020? The amounts, it's $1,200 per person. So a married filing joint taxpayer would receive $2,400 as a rebate. You would also get a $500 per dependent child under the age of 17. Now this does phase out. So for individual taxpayers above $75,000 in adjusted gross income, for every dollar above $75,000, basically there's a 5% reduction in your rebate. And so with married filing joint, that's 150. So I think at 198,000 in adjusted gross income, a married filing joint couple would completely phase out of the $2,400. Now the phase out does apply to the $500 dependent credit. So if your AGI is above 198 and it keeps going, then you could potentially phase yourself out of those as well. A couple things to note on this is that if in 2018 or 2019, the most recent tax return that you filed that they're basing this off of, if you are over the phase out limit and you don't receive a payment right now, if in 2020 your income goes down to a level where you're under the phase out limit, you will actually be able to receive this credit when you do your tax return in April of 2021. On the flip side, if you're under the phase out limit for 2018 and 2019, so you do receive the cash payment, and your income, there are some industries out there who are doing well because of this pandemic. And so if your income goes up in 2020 over the phase out limit, you will not be required to pay that credit that you received back. So there will be no clawback. Obviously, anything that happens in 2020 can affect this, births, deaths, divorces, anything like that happens in 2020 could affect the rebate that you receive on your 2020 taxes when you file that. And then your payments don't affect, these payments don't affect your eligibility for federal programs. And so the next thing I want to talk about is the coronavirus related distribution. So basically what this is a distribution from an IRA or a 401k that is due to COVID-19. So what does that mean? means you've had COVID-19, you've been diagnosed with it, a spouse or dependent has been diagnosed with COVID-19, or you've experienced adverse financial consequences due to COVID-19. And that could be, you've been laid off, you've been furloughed, you've been quarantined, you've had your work hours reduced, you can't, you're unable to work because you have to take care of a child whose daycare closed. They left this broad to give the public a way to use these funds if needed without facing some of the normal penalties and tax consequences that you normally would. And so what does it mean if you take a coronavirus related distribution? So typically, if you take money out of these accounts before you're age 59 and a half, with some exceptions, there is a 10% early withdrawal penalty. On distributions up to $100,000 that are deemed coronavirus-related distributions, and that is a self-certification. But those withdrawals up to $100,000 do not receive that 10% early withdrawal penalty. You can pay the taxes on those distributions back over, you can claim the income related to those distributions over 3 years. So let's say you take a $99,000 distribution out of your 401k. You could technically say, okay, I want to be taxed on $33,000 this year, $33,000 in 2021, and $33,000 in 2022. That's the default. You can actually elect to have all of it taxed in 2020, and that may be a good financial planning tool if your other income in 2020 is low. It just depends on your whole tax situation. That's why we work with our clients on their entire financial blueprint. You can actually repay the distributions within 3 years from the date of the withdrawal, and you won't incur taxes. So like, say I took a withdrawal coronavirus-related distribution today, I would actually have until 2022 to pay that back. You might have to file amended tax returns to true up the taxes, but you could technically do that. So basically, you can borrow from your IRA and put it back in within 3 years without paying taxes. And also, one thing to keep in mind on this: those repayments not subject to the typical contribution limits of IRAs and 401ks and things like that. Within 401k plans, a lot of plans allow you to take a loan from your 401k plan. So in the past, that has been the lesser of $50,000 or 50% of your vested account balance. That is now increased to the lesser of $100,000 or 100% of your vested account balance. So basically, you can take more of a loan out of your 401k if you need to weather the storm of the coronavirus. And those payments can be deferred for up to 1 year going forward. And so the next topic is required minimum distribution. So the CARES Act actually waives required minimum distributions for 2020 and those that were supposed to be taken in 2020. And what does that mean? So if you turn 70 and a half in 2019, and your first required minimum distribution would be due by April 1st of 2020. If you didn't do that and you haven't done that, that is actually not due because of this as well. And the RMD that you would need to take for 2020 you don't have to do that as well. This applies to IRA account owners, but it also applies to beneficiaries of inherited IRAs. So if someone passed away and left you their IRA, typically you have to take that over your lifetime. There's been some new legislation starting in 2020 that changes that. But that's typically the case. And so if you haven't taken that already, you don't have to satisfy that either. There's some rules that if you've already taken your required minimum distribution in 2020. So say the new year turned over, you want to just go ahead and take it. You have to, before all this happened, you had to take it at some point anyway, and you went ahead and took it. And then this happened. And you don't really need the money, but you took it because you had to. You may have an opportunity to actually roll that money back into your IRA if you haven't done a once per year rollover. If you're not prohibited by that rule, you may be able to roll your money back in, and it would be like it never happened. And so typically for required minimum distributions taken from February 1st through May 15th, the period of time that you can roll that back in, it's typically 60 days, but it's been extended to July 15th. Unfortunately, if you took your distribution real early in the year in January, for everything that I have seen, you won't be able to roll that back in. Now, this is like Tom and Ashley mentioned. There's a lot of change that is going on right now related to this, and so there's actually some thought that they may go back and change this. They being the IRS, to allow people who took them early in the year to take it, and even get rid of the 1 per year rollover rule limit. But that's one of those situations where if you run into that, it'll be case by case whether you can pay it back in. If you have an inherited IRA, or a beneficiary IRA is what we call them, and you've already taken that required minimum distribution, so you're not required to if you haven't already, but if you have already taken it, you're actually not going to be able to, under any circumstances, roll that back in. So it kind of is a done deal. And then you can also, one thing, since there really is no required minimum distribution, you don't have to take them this year. You could, the required minimum distribution, if you took it out and you're not able to recontribute it as a rollover, you can Roth convert those funds. So if you took the money out, you're paying tax on it anyway. If you can't roll it back in theory, you could take that and roll it into, or convert it into, a Roth IRA. Now, in normal years, you can't do this. You can't satisfy a required minimum distribution by putting it into a Roth or converting it to a Roth. But since there's no required minimum distribution this year required, then you can do that. I would caution doing that at this point, because if legislation changes and they come out with more guidance, you may be able to just roll it back into the IRA, and then there's no tax consequence because you could do a Roth conversion anyway. So the next slide, Felicia, is so tax returns and tax payments. So most of y'all have probably heard by now that they have extended the filing and payment deadline for federal tax returns and payments to July 15th. That also applies to quarterly estimated tax payments that are due on or after April 1st through July 15th. You can actually extend that and push that out until July 15th without any penalty. So the next slide is charitable donations. So the CARES Act includes a provision that allows you to take a $300 above the line deduction for cash donations that you give to a charity. And so basically what that means is even if you are taking the standard deduction, which a lot of people nowadays are, just because it was increased with the Tax Cuts Job Act a couple of years ago, you can give $300, say, to your church, get that as a deduction above the line, and then still take your standard deduction. So it's not much, but it is something. The CARES Act also increases the AGI limit on charitable contributions from 60% of your AGI to 100% of your AGI for those cash contributions. You can't use donor advised funds and things like that in this. Anything you put in, you can carry the excess up to 5 years. So anything, if you gave more than your AGI, you could still carry that forward for 5 years into the future. So in theory, with a cash donation to a charity this year, you could effectively eliminate your entire tax liability. I don't know a ton of people that would want to give in cash to a charity in 1 year the amount equal to their adjusted gross income, but you in theory, you could do that. So the next slide is related to student loan relief. Some student loan relief is that so all principal and interest payments on federal student loans can be deferred without penalty. The payments can be deferred without penalty until September 30th of 2020. And then also, if you have defaulted on a federal student loan and the government is garnishing your wages, your Social Security, things like that, you get a reprieve from those garnishments through September 30th of 2020 as well. And then also employers can provide up to $5,250 in tax-free student loan repayments to their employees through the end of 2020, and that's not included as income to the employee. Now, there's already a provision where you can provide that benefit for ongoing education or current education, but this now makes it apply to loan payments that those employees are making. So medical and healthcare provisions, real quick, qualified medical expenses for HSAs, so your health savings accounts, your flex spending accounts, things like that. Because of the CARES Act, those have been extended to over-the-counter medication. Medicare beneficiaries that receive the COVID-19 vaccination, when it's available, they don't have to pay for that. And then Part D recipients can get up to a 90-day supply of medications prescribed and filled, whereas before they may not be able to do that. And then the telehealth services that are covered by HSA eligible high deductible healthcare plans, you may be able to have those services are covered without meeting your deductible. So you'll actually be able to get a benefit on those without hitting into your paying into your deductible. And so expanded unemployment. I know we touched on this a little bit, Tom and Brooke did, but this is extended to self-employed individuals, contractors, freelancers through the end of 2020 up to 39 weeks. And then the federal government's also offering states to cover the first week of unemployment that sometimes is not covered. It's similar to like an elimination period with a disability insurance. But the government is offered to pay the states to cover that benefit for employees. Like Tom and Brooke mentioned, this adds up to $600 per week on top of the unemployment benefits somebody would get from their state for up to 4 months, which, as Tom and Brooke were mentioning, incentivizes a lot of people to want to claim this benefit. It adds 13 weeks to the unemployment insurance. So anybody that's before this was nearing the end of their time, it actually adds 13 weeks onto the end of that. And then if you're a new filer, it just extends the period to 39 weeks. And it provides states incentives to provide unemployment benefits to those employees who have seen hours cuts and income reductions, but who are still employed. So to give them some relief because their income has actually gone down. Employer retention credits. So this is, Tom and Brooke, I think hit on this as well, but this is basically moving in from individuals into kind of some small business situations. So the CARES Act is providing payroll tax credits for employers not participating in those debt forgiveness SBA loan programs like Ashley went through. To qualify, you have to have operations fully or partially suspended, or your income or revenues have to be significantly down 50% from the quarter in 2020 versus the quarter in 2019. And those will continue until the end of 2020, or a quarter when the government suspension is stopped, or where gross revenues from last year's quarter are up to 80% in 2019. So basically, when your operations get back to somewhat normal, these credits won't be applicable. And so the credits equal to 50% of the wages paid to each employee, up to a maximum of $10,000 of wages per employee. So about a $5,000 credit's the max per person. Fewer than 100 employees, all wages count basically. More than 100 employees, the business, only wages paid to those individuals who are not working because of the government shutdown or the revenue decline as above would apply. And then, so payroll tax deferrals. So if you're not participating in the SBA loan forgiveness programs, you can actually defer payment of your payroll taxes that are due in 2020 or would be due in 2020 from the date of the CARES Act through the end of 2020. You can push those out to the end of 2021 for half of it. And then the other half you would owe by the end of 2022. And this also applies to self-employed individuals, their employer equivalent portion. So they're paying both sides of the payroll tax. And so half of it, this applies to half of that for them as well. And then the last thing is net operating losses. So any corporation other than real estate investment trusts that are now allowed to carry back net operating losses in their business from 2018, 19, and 20. You can carry those back 5 years. And so that would, that could potentially reduce your prior year tax liabilities. And you can do that through an amended tax return and get some of that back. And then it also amends the law to allow for up to 100% of your taxable income to be offset by those net operating losses in 2018, 2019, and 2020 going back retroactively. And so that was a lot of information. I tried to cover it quick because I know we're coming up or over our time limit. But if you have any questions, please let us know. Our website is fiveplanpartners.com. You can get all of our contact information there. And a lot of these specific provisions in this and other things really depend on your holistic, comprehensive financial plan. And so that's kind of how we work with our clients to build their whole entire situation and then kind of look and see where these different strategies. There are some strategies within the CARES Act, especially related to the required minimum distributions and the coronavirus related distributions that we can help our clients with. But just wanted to give a brief overview of this. So I appreciate everyone's time, and then and that's all I got, guys. If y'all have anything else.
Other than that, we're just greatly appreciative of your time.
Absolutely. Yeah. Thank you for taking your time out today. And if y'all need anything, let us know. And Tom, I appreciate you and Brooke. I learned a lot about employment law that I never knew before. So I thank you for your time as well.
And remember, if you have questions that you didn't want to ask here, we got an email and telephone numbers that were on that last slide. And I guess with that, I think we're done.